Just check it's showing. Hello everybody. I hope that we're going live now. I'm just waiting to see if it comes up. There's a little bit of a delay on YouTube itself, and once it does, then yes, that's right. I'll mute this. Check it's showing, so I know we're live. Hello, and I'll just go back to that one. So it's another session, and I've got with me today. I've got Mike, Shannon, and Karis again. And thank you all for taking part. And forgive me for the graphics; it's a bit amateurish, but it should. If it doesn't work smoothly this time, it'll work more smoothly next time. But what this is supposed to do is what I've got at the moment on there is the one with the comments on, so that if somebody puts a comment in here or anywhere, I'll just show you a test. It should appear, yeah. So we can accept it appears twice because it was me doing it on Zoom and YouTube. Can you see it at your end? It won't appear on the live stream yet, but if I don't know if I can delete that, but that'll make it easier because I can scroll down rather than having to highlight one particular one at a time. Although it did occur to me that they are showing on YouTube anyway, so if people can see the actual YouTube channel, then they can see the comments there. So the things I had to talk about this week is there's not all that much, but I'll just go back to the beginning and talk about that. So if I go to, I think I'll start off with this GP report if people can handle that. And it's not actually a GP report, it's a post, it's a comment on my blog from a GP in response to an article or a post I did 2 years ago. And the nice thing about the internet is that you can do a post in May 2022 and somebody finds it in October 2024 and can comment and can put a reply. And I thought I would just go through this and get your comments and anybody else's, because I did say at the end of my post I'd like to hear from GPs. So what I was essentially saying in there, you can read it at your own pace if you like, but what I was complaining about was it was quite common for GPs to refuse to provide reports, which is causes a big problem if you're trying to deal with somebody who needs evidence that they're vulnerable for a 202 review or something else, or whether their accommodation's having a bad effect on their health, and whether their condition amounts to a disability. So I said that most GPs are very helpful. However, some surgeries, the staff were refusing to provide reports, and that was the case even if you offered to pay them. So it wasn't just the problem of being asked to do something for nothing. And I have heard of GP surgeries where there's signs on the wall saying don't ask for a letter about housing in reception and stuff. And I don't know if that's because they don't want to be paid or sorry, they don't want to do it without being paid, or because they're just fed up with being asked to write letters and they're not. So if you don't mind, I'll read this comment out in full and then we can go through it. So Dr. John Smith, who has said before we started, is I suspect not his real name, but fair enough, or her name. I don't blame you being anonymous. You never know who's reading these things. So he says, interesting perspective. And he says, would I like to work if I wasn't being paid for it? Probably not. So why should the GP? To put things into perspective, a GP typically receives about 5 of these types of requests per day. There is no clinical time allocated for this new wave of work. So if each one takes 15 minutes to deal with, that's easily an hour of unpaid work being done, or time staying into the evening beyond what is already an overfilled day. Most surgeries close at 6 and the GP might leave around 7. Do they want to stay around till 8 p.m. doing this sort of admin thing for free? A GP exists to diagnose and treat disease in the community. They do not exist to take the underlying responsibility for housing eviction decisions and have no training in this field whatsoever. The simple solution is to pay them for their time to do these reports and letters. Some surgeries still won't do it, as the amount being paid is so small. The solution is to pay them more or use a private GP who will spend the time going back through the patient's entire medical history, often complex and could span 80 years, to produce a letter or summary for you. A reasonable charge for this is whatever you would expect a professional spending 15 to 20 minutes on something, which is then typed up by a secretary, addressed and posted out. And we've got some I will just, I'm sorry if it's a bit tedious reading the whole thing, but I think it's worth it. A junior solicitor charges £20 to certify a copy of a passport, which takes approximately 2 minutes. This is essentially unskilled work with no consequence if the work is done poorly. It would seem reasonable to charge at least £150 to £200 for a medical summary of the effects of somebody's medical condition on their housing situation, such as the one you describe. But strangely, nobody wants to pay that much, and often GPs charge as little as £30. So this is why it's hardly an appealing task. We have to start realising that the GP is not the go-to for our life admin items. Unfortunately, many businesses and organisations are now quite confidently telling people to speak to their GP, or often seek a letter from their GP for things that they would like the GP to take responsibility or risk for. Sadly, this is unrealistic, and GPs are cottoning on to this now. An example is sporting event organisers asking a GP to say someone is fit to compete in a marathon in order to shirk the responsibility if the person dies in the competition from a medical issue. If we choose to still ask them to become involved in our personal administration, we need to pay them for their time. The other important thing to recognise is that GP surgeries are businesses who are contracted to provide a range of services by the government. This sort of work is not in their contract, so they have no obligation to do it, despite what people may wish. If you want to contact a GP to do some work for you, which is not in their contract, then they are entitled to decline. People may feel that this is a harsh line to take, and the poor person with the medical issue is the one losing out. The reality is that the real crook here is the organisations who are putting barriers in place to these people by asking them to go around the houses getting all sorts of additional evidence, GP letters for things which don't actually need medical input. Last time I moved house, my solicitor didn't fancy also sorting me out with a prescription for medication for my headache on the side. It's odd that they expect it the other way round. Well, there you go. I sense a sense of frustration there, but I don't want to get nasty about this, because I think maybe Dr. Smith is letting off some steam rather than making serious points the whole time. But what do you guys think? I'll stop talking for a sec.
I mean, I think it's useful for us to kind of. I think there's some kind of maybe misconceptions in there about what is actually being asked of them. I don't really see how there would be any risk attached to giving their opinion of someone's medical issues around homelessness. In one sense, there's risk of not doing it rather than risk of doing it. I just genuinely can't see a situation where they give their opinion and then it somehow comes back to bite them, assuming they, do a competent job of it, which isn't difficult. So yeah, I think as I say, I think it's probably a useful window into the mind of a particular GP. But I guess the question is, well, why do some GPs still do it? And presumably it's because they do see it as part of their role to ensure the well-being of their patients. Yeah. So yeah, we might end up having a long conversation on this thread at some point.
I mean, I don't want to speculate too much about this GP's personal life, because obviously it's not my job and I'm not getting paid for it. It sounds like he's just deeply unhappy with his job. Like, there's a lot of illogical fallacies in there around the marathon and when he moved house. That's not the same thing as well. Like, and when you look at the homelessness sector and the fact that there's quite an acknowledgement now that housing is a health issue. Like, when you look at the health statistics from people in TA, you look at the health statistics of people who are homeless, you look at the life expectancies of those who have rough slept, like, it's not far-fetched, and it's not people aren't doing this for it's not the same as a marathon in no sense, way, shape or form. And so I think actually it does fall under the bracket of their job. I think he makes a really valid point about them not having training, and I think actually that's a solution for me. Is you train GPs on how to write a really effective legal supporting letter for priority need. And that I think as well, if GPs got that training, it wouldn't take as long as this guy is saying, and it would cut down, and it wouldn't feel like admin either, because you're not just compiling a list of diagnosis, which is quite admin-y. You're actually, helping someone's situation. And again, I probably agree on sort of like the real crook maybe being sort of local authorities needing this evidence and everything else. Like I get that, but like at the same time as well, when we're talking about multi-agency working and rah rah rah, like I don't know, it sounds like he's a bit unhappy in his job. I don't know if I've gone on too, if I was too mean there, apologies, but I'm gonna shush now for a bit.
How about you, Karis?
No, I would completely agree with Sharon. I think if you look at what he's talking about, is quite a big difference from running the marathon to being homeless. And look at the health statistics. If he's going to put someone at risk of homelessness and the risk to him or her, so then he's got the double-edged sword of if he doesn't do it, what's going to happen and what health complications has he got to deal with afterwards? And isn't there a Hippocratic oath to not do any harm to anyone? Surely not helping someone with homelessness when you can write a recommendation, this person who has all these disabilities, this diagnosis, it's on this medication. If he's suffers with homelessness, he will suffer harm that this person can stop. And training them, I think GPs and the multi-agency approach needs to be addressed, because that should work more often than it does. And if they did do training, he would have someone to ask questions of how can I make this quicker? All right, this is clearly something that needs addressing. If all GPs are putting a note up and a note up on their website, this is clearly something that's getting kind of out of hand. Let's try to nip it in the bud before it gets completely out of control. But no one's seeming to take that approach of preventative measure rather than it's now at crisis point. Let's just deal with all the cases that come in. Okay, we're not doing anymore. But then look at the knock-on effect you're having. Let's try and implicate preventative measure and how everyone can help each other. Why the local authority asking for all this stuff when they should just be helping people and not gatekeeping?
And I think that's a really interesting point, Karis. Like when you talk about prevention and stuff as well, I wonder how many people have gone to their GP and like basically said that their housing is unsuitable for their needs, whether that's physical or mental health or whatever, or whether they've said actually I'm really depressed because I can't afford my rent. And like, the GPs aren't trained to recognize homelessness. So actually that prevention that you talk about, a GP could be in a position, they're under duty to refer now, and I know duty to refer doesn't concept like a homeless application, but if they had proper training, they could be so vital in prevention. It's a really good point. Sorry, just jumped on that, but it was really good.
And they could just say, just go run a marathon instead.
Go what? Go to America.
Go to run a marathon. I'm just googling like the amount of how much it actually costs. So got a few sites here saying that a GP appointment, which is about 10 minutes or whatever, is 30. It costs the NHS £36. So I mean, I'd say I'd be perfectly happy to spend £150 to get a decent GP letter because it's worth its weight in gold. But I don't think it'd actually cost that much. I mean, how long does it actually take? I mean, now medical, they do their letters in 9 minutes or something. If you look at the amount they get for it and kind of how much it would cost them. So it just seems like, I don't know. I'm just glad there's a lot of GPs out there who are a bit more helpful, I think. But yeah, I think if the surgery had like a policy saying if you spend £150, we'll give you a detailed letter, I'd be like, yeah, fine, whatever, let's pay it. So get the person housed, because it will all ride on that GP letter basically.
I think I should say that the legal aid agency pay £72 as a fixed fee for a letter, or if the GP thinks they need to spend more than an hour, they'll pay them at £72 an hour, as long as the invoice says how many hours they've spent at £72 per hour. So looking at Dr. Smith's figures, Does that mean if he thinks it takes, did he say 15 minutes? If each one takes 15 minutes to do, which I think is maybe a bit less, if you'd be a bit generous and say 20 minutes, that's not bad. £72 for 20 minutes work isn't too bad, is it? And if they did need to go through, but I mean, I don't know how long it takes to do it, because if the GP knows the patient really well, maybe they can write the reports off the top of their head. But if they have to go and access all the medical records, and in my experience, medical records, there's quite a lot of stuff to get through if you're not familiar with the case. Loads of it's just text, copies of messages that have been sent out warning people about COVID and stuff. So I hopefully that's not too bad a fee. I guess it must be really frustrating, because as a solicitor, I sometimes feel angry that I'm the only person who's supposed to be doing my job properly in the equation that I deal with, because I deal with local authorities that seem to just, that's the reason we do a lot of our work, because local authorities get it wrong. The court service is on the verge of breakdown and takes months to do what should take only days. And I'm trying to think of other people that I can slag off. But sometimes when I'm knackered, I think, bloody hell, I'm a social worker. I have to diagnose people. So I can understand it must be even worse if you're a GP, because if it's bad enough having people with legal problems banging on your door, but if you've got people who are in pain or worried that they're going to die, or are experiencing mental health problems, I suppose it must be a really frustrating job. But one thing I would say as well is that I think that we ought to be working together, and that in the future, I tend to think the sort of work we're doing, like GPs, should be perhaps funded by the NHS or seen as part of the NHS, rather than just Ministry of Justice, because sort of sorting out a homeless decision has more in common with a medical practitioner, to me, especially if it's about a medical issue, than representing somebody at the Old Bailey on a murder charge. But that's just, the law, for some reason it all gets classed as law. But I just bring this comment in. We've got, hello Cheeseface, nice to see you, and thank you for your comment. And that raises the question of social prescribers, which I take my hat off to whoever came up with that term. It sounds like something out of a rock opera or something, doesn't it? But a lot of surgeries now have these social prescribers. I don't know if anybody's had an experience of them. And that may be a solution, that you can say, I'm too busy, I'm a GP, I'm treating people, go and see the social prescriber. And that sounds like, it's a bit like social worker, isn't it? That they will prescribe social solutions to your problems. I haven't had that. Yeah, go on.
They'd be well positioned, like, so where you've got surgery, you've got social prescribers. If social prescribers are good at their job, then they'll have a good relationship with the GPs. And I've never been one, but when I was a recovery worker in a drug and alcohol service, it's a similar kind of principle where they're saving money by getting just kind of, mugs like me to run around and do all the legwork. And you kind of set the prescription up, you kind of do all the stuff, and then the doctor just signs it. In the same way, if social prescribers, if they knew what they're doing, they would write the letter, talk to the GP. The GP's happy with what's been written. They just sign the letter, and then it's the GP's opinion. And then so you've got something which is quite workable. I guess it depends how the social prescribers are set up. Like if they're covering lots and lots of different surgeries, and so they don't really kind of get to know the doctors. But if they were to do that bit of work, then they would be very well placed to kind of basically churn out decent medical letters and just kind of get a doctor to rubber stamp it and have a look through it.
Yeah,
they potentially are. Sorry, go on, Will.
Go on.
I was just going to say they're potentially, because I was just thinking, like, what you were saying about your work, but you've come up with like a level of template stuff. Now, I'm not saying, like, obviously everyone's case is individuals and like but as a general rule, if person A and person B both have anxiety, now it might come from different places, it might, affect them in slightly different ways, but their ability to deal with homelessness, that effect is probably going to be fairly similar. So if you've got like common conditions, and say like old age being one as well. Old age is going to affect different people in different ways, but with their ability to deal with homelessness, it's probably going to be roughly the same way. So like, if the social prescribers are in less of a firefighting position than the GPs are, then potentially that's something that they can come up with, as well as, you know, taking stuff to committees and everything else of like, we've done X amount of letters this week for people who are clearly in priority need. What are you doing? And it just a bit more of that bigger picture-y sort of thing, which I know obviously maybe, yeah, the GPs don't have the time to sort of do.
And I
Yeah.
would also add, if you know, there it is well acknowledged that the NHS is in crisis and has been for quite some time. So why are we adding pressure to them and putting the onus on this one letter rather than thinking of other solutions? For example, the housing officer working with the homeless person, a person that needs help, if they're clearly in priority, why are you sitting there going, oh, we just need to confirm the GP to confirm kind of what they already know? So instead of going, oh, all this information on this service that is in crisis saying we can't do anymore, we can't do anymore, instead of someone going, okay, let's look at this and be more constructive, they're going, let's just hammer up the, you know, put the head against the brick wall and keep going on the same thing. If something's not working, you know, go a different route. So try and actually talk to your person that you're supposed to be prescribed to.
Yeah, well, I think that's probably enough on GPs. Just to say, if I go back to Cheeseface's comment here, if Cheeseface, if I don't know if you or anybody out there in London or elsewhere has had experiences of social prescribers, I'd be really interested to hear more about those experiences, because I think it's a really positive development that this role has been created, and I hope it lives up to what it needs to. So is there anything anybody else wants to talk about before I move on to the nearly legal report that we're going to touch on? Okay, so I'll move on to that. Hopefully it'll come in. Forgive me if the graphics mess up, but is it that one? Yeah, hopefully. Oh no, it's this one. Sorry, bear with me. There. So this just came in yesterday. In fact, you can see how hard Giles Peaker works, because I mean he's in addition to being I sound like his #1 fan, but I'm sure I'm not, but I'm always sort of being obsequious about him. But he in addition to working and writing books and doing casework, he's blogging out on a Sunday, which if I started doing that, I would. I mean, I do sometimes, but I find I have to take at least 1 day or 2 days a week off just to sort of free my head up from legal white noise, as it were. But he's put this very useful post out, which I think we should discuss in more detail another time. But I wanted to flag it up because when we do the live streams, particularly on Mike's channel, on Mike Chandler's channel, I always feel like Mr. Negative in that a very frequent question could be paraphrased as being, how long do I have to wait before I get a council tenancy? Or when am I going to get permanent accommodation? Which is sort of, I think, what people mean. Or that's the only thing that comes close to permanent. And I always end up saying you can't get that anymore. There's no more social housing left, really. And you're really only going to get, realistically, you're only going to get an offer of private sector accommodation. And I hate to say as well, if I'm being really negative, and if you get one within a reasonable distance of where you want to be, that's good as well, because you might be at risk of being sent off to north of the wall, as it were. So this case illustrates it, and I'd like to. I mean, if people take the time to read the actual judgment, what you tend to get in law reports of this kind is a good summary of the law. So I mean, nearly legal summarizes. Giles summarizes the decision here, but the judge will have done a summary of what the statutory provisions are and so forth. But the essence of this decision is that the challenge was that Enfield had not given somebody enough points or status on the allocation scheme put them in the queue for social housing because of their medical conditions. So they'd got a certain number of points for being homeless and being owed a statutory duty, but they didn't get the extra. And I think the reason they weren't happy about that was because they knew in practice that would mean that they were just in the queue and they weren't realistically going to get to the front of the queue. And what the judge said was that if you go down to the end here, yeah, I mean, they were saying that reasonable adjustment, which had been part of the challenge, to say that if your normal procedure is to do X, you ought to do Y and Z in the light of the fact that this is a disabled person and you have to go the extra mile to meet their needs. But they're saying no. What you need is they've got a policy, they've got an allocation policy, they've thought it up as the best way to allocate scarce resources, and you can't challenge it even on the basis of disability discrimination, and just because they're not getting to the front, which shows the real policy oblique legal approach, which is that you've got to stop. I mean, I hate to say this, but I'm not that I want to do this, but the system wants to stop homeless people clogging up the front of the homelessness allocations queue, because this is what happened 20 odd years ago. The only way you could get a council flat was really to be homeless, and then you jump the queue. And it's a concept that is it. I mean, I'm not sure. I mean, I think maybe homeless people should be jumping the queue. But then again, who are the other people that want social housing? The test, the example always used to be some sort of non-homeless person, a young couple, a bit like in the 1950s or something. A young couple get married and they live with one of their in-laws, and they're living in the room waiting for the council tenancy, and they're waiting patiently. They're not jumping the queue or going down the homeless persons unit. And they obviously get passed over every time a homeless person goes in. But I'm not sure. I don't know what people think, but I'm not sure how much that's a reality anymore. But this just illustrates to me how difficult it is to try and challenge getting stuck in the queue for a limited amount of resources. So, any other thoughts on this? I've been rambling for a bit there.
I know it's on a bit of a tangent, but it kind of relates to what you're saying. So I think an interesting thing is that on the housing register, so you have three cohorts of people: homeless people, kind of direct Part 6 applicants, and also transfers. But when you actually start looking at, so let's say, for example, most policies will have something for people who are under occupying their accommodation, as in they're paying the bedroom tax. But in many cases, they'll actually be legally homeless because they can't afford their rent because their income's not enough to cover it. So you've actually got a lot of situations when people will be kept under Part 6 and under the transfer kind of cohort, but really they should be being dealt with as a homeless person anyway. So in one sense, if you think of homelessness as being, well, almost it becomes by definition a way of prioritizing the most people in the most need, and that's how it should be dealt with. So I've kind of raised this with Bedford before, where I've said, they've kind of said, you need to balance the kind of cohorts and how much access there is. But I'm like, well, that in itself doesn't really kind of recognise the fact that some people who have been dealt with as transfer applicants actually are homeless, and there is an urgency to what they're saying. And so if the council just followed the law and treated them as a homeless person, which is what they should be doing, then you would have kind of a natural prioritisation of people who are most in need. But that doesn't seem to happen. And so in one sense, what we're seeing in Bedford, they've increased, or they are likely to increase the allocation of properties to homeless applicants further than they already have, because it already went up to 40% from 33%. But if they actually follow the law in other areas, then it actually doesn't make any difference, because all those people who would otherwise be in transfer in Part 6 are actually going to be dealt with under Part 7 anyway. So it kind of needs a little bit of careful thinking to kind of work out how the council actually needs to do a good job with this. But yeah, it just seems to be something that gets missed, that many people who are getting priority points for some of the reason, like medical issues or something like that, actually for the same reason they're actually legally homeless, even though they might have a tenancy. So yeah, I appreciate that's not exactly what you're asking, Will, but I just thought it kind of is vaguely relevant to what we're talking about.
One thing I will do, and I hereby pledge that I will do this. So I will read this properly. I mean, I had hoped to do it this afternoon, but sort of things got in the way. I will go through this and maybe use it as a model for looking at what the actual summarising the law and how difficult it is and what ways round it there are. And maybe we can bring that back next week, because I think it is a key issue as to what extent can people expect to get into social housing, and to what extent am I being unnecessarily pessimistic and lazy in not challenging situations where people want social housing. I've got a comment here I just bring in from Andrew, which covers both our topics nicely. So thank you, Andrew. That we got somebody who did get into social housing, and they did it with the help of a GP letter, which I guess shows that it can be done, and also how important GP letters are. So I guess we just got to keep plugging away with asking GPs for letters and saying how important it is. I should stress that my experience of GPs is, I mean, I hope it doesn't sound negative, that when I was writing that post that Dr. Smith responded to, I was feeling a bit negative, but the majority of GPs are really, really helpful, and some of them are just outstandingly good and write really good reports. So it's not a universal problem. I've got another question from Cheeseface. Oh no, hang on. I'll just try this thing. Forgive me if it goes wrong with the graphics, but I should be able to put all of the comment. Yeah. Can you see this? I mean, it'll take. What you can do with this is see. No, you can't. I'm supposed to be able to scroll up and down this. I'm just trying to see how to do that, but maybe it's not. Never mind. I'll come back. I'll just do it this way for now. So Cheeseface has put another question. Oh no, it's working now. So except it stopped working. Right. So go back. Oh, I know why. Sorry, it's because I have to move it here. Sorry, I'm learning this technology, but it is getting easier each week. So we've got. Oh yeah, we've got a comment about a social prescriber. Person X is currently using one based in the surgery every Monday and Friday, so not ideal. Person X asked him to state case to local councillors following HBP advice. They did respond quickly. Anyone going to beat me to guessing what HBP advice is?
I think that'll be us. Holmes is best practice. I'm thinking.
Yeah, sorry, yeah. So, forgive me. Actually, I was thinking it was some sort of procedure in a GP surgery. Says, of course, yes, taking up the case. Yep. So that makes sense. And they did respond quickly. And then we've got a friend of mine. We got that one. So we've got Cheeseface asking the general question here. Will, when you take on a case, do you deal with any discrimination that the council may have committed as part of the case? Yes, I think I do arguably, but it's so difficult to say confidently, because I mean, I say in possession cases, I often deal with cases where it's clear discrimination, where somebody has been unwell and not able to pay their rent. I mean, one poor guy was sectioned in a mental hospital, and they were still trying to evict him for not paying his rent. And so, yes, I can say, well, this is clearly discrimination. It's adverse treatment of somebody because of something arising out of a medical condition or impairment. But it's difficult because discrimination is an easy thing to call out, but not. I mean, you can then have an argument about it. So, I mean, the simple answer is yes, but not as often as perhaps I should, because I tend to think I might be just seen to be crying wolf, or if I just start looking at discrimination straight away. And yeah.
So, if I can, I'm probably being really thick, and I haven't read the article properly. I've just purely skimmed it, so please bear with me. But it's around that discrimination thing, because it says there was not a duty to monitor. However, there was a duty of inquiry if the relevant information that could satisfy the authority was not available in regards to the PSED. But then it says that it did support that Enfield is failing to collect and analyse data around disabilities. So I'm like, well, what, like, maybe I just need to read into it a bit more, but that
Yeah,
sounds like discrimination to me. If they're not doing something in regards to people with disabilities and they're failing to do it, whether it's a duty to monitor or a duty to inquire, which again, hate the legal system, because how can you do an inquiry if you're not monitoring? Like, you've got to have the data to dig into in order to have an inquiry. So therefore, I get this not the duty to monitor, but to carry out the inquiry, you must have some sort of monitoring. And again, like, it feels like they're saying it's not discrimination, except for you have failed to look after people with disabilities in regards to the public sector equality duty, which in my mind, I don't know. I don't know if maybe I just need to go away and like read up into it a bit more,
I've
but
definitely
it's
got to go and do that, which is why I'm going to read it in detail. And maybe let's definitely come back and talk about this next week when we'll have had a chance to look at it, and the issues it gives rise to, which is when you can. Because I think, Mike, I think you made a comment recently that if you had to predict when people are going to get social housing, I mean, it's usually only because you have a disability which would prevent you from being able to live in private accommodation, which is not the same thing as, well, it may be actually. I haven't read this here, but I mean, for instance, if you need adaptations made and private landlords won't agree to do them, then it would have to be social housing of some sort. So yeah, let's come back to that. We got Andrew's added that the GP didn't charge. Oh, this GP is getting better. I'm feeling more and more positive now. So the housing association awarded priority within a month, and he had the keys within 3 months. Well, that sounds great. I guess there's always exceptions that prove the rule. I mean, I think the experience for most of us is people are waiting 3 years and they don't get anything, and their GP, even if their GP writes really good letters. So that's, sorry, my doorbell's ringing, but somebody else will get it. So anything else anybody else wants to raise? I'm conscious we're only a half an hour into it, but we don't have to go on for a full hour. But we can do. I have a little project I could tell you about, which I haven't got any graphics for, but I'll keep you informed. I've noticed that for me, this is more for caseworkers and solicitors and people working in IT around this area, is that Microsoft Office, this sounds incredibly boring, tell me if it gets really boring, but Microsoft Office has sort of developed over recent years from what I used to use. I mean, I stopped using it for a long time, or other than Word and Outlook. And there's all these new apps that they've got, like Planner and Teams and SharePoint and OneDrive. And the thing that occurred to me was a lot of firms of solicitors and organizations have licenses to use this software, and they've got it on the system, but they're only using the system for a sort of 1/10 of its potential. I think it was Harry Hill made a joke once about, I think he'd got his grandma a computer and she was making good use of it as a lamp, which was what a lot of people are doing. So I've signed up for a course, and I'm going to go. I found somebody on YouTube that's doing Microsoft, training and coaching people to use Office 365, and I'm hoping to then be able to maximize the use of it. Because I mean, I had no idea. Do other people? Maybe I'm getting old and not in touch with things. But the Microsoft Teams, I thought that was just some sort of version of Zoom, but it's actually a sort of whole infrastructure of collaborating, and you can do loads more with it. So that's something I'm going to learn up and hopefully report back on, because I think it would be useful for everyone if we can work more seamlessly.
Yeah, I think there's a lot of resistance out there to that sort of stuff, me included. Like, I think how many professionals I see, they can't even use kind of basic functions of their software. So I think I mean, I think you're right. Just kind of seeing how you work with, in terms of kind of, you've got your templates and all that kind of stuff. It works really well. And I don't think that's really kind of got out there for whatever reason into the wider workplace. But it would do a little good if it did. Yeah.
Well, I've always been very keen on using technology or utilizing technology to help in this sort of area. And I think a lot of solicitors are guilty of not doing that, and also making a virtue of not doing that. It's very common for solicitors to say things like, "Oh, I don't know anything about IT," and "Ha, that's really funny, isn't it?" And I think, well, no, it isn't really, because you that's the reason you haven't got any capacity to take on clients, is because you're taking 5 times as long to do what you should be doing, what you could be doing easily. So yes, more to follow on that. We've got some more questions here. So yes, it was homeless best practice. Yes, thanks. I think everyone else spotted, thanks, like me. If person X was currently making an application at Virgo, would they need to ask for you specifically? So for anyone who's not familiar with what Cheeseface is on about, the Virgo is a firm of solicitors I work for. It's one of 2. I do consultancy work, and we're trying to sort of meet the need, because there's just huge deserts out there of where people can't get any advice. And I felt a bit disingenuous or in doing these sessions, because people have been asking, can I get a solicitor? And I could say, yes, hello, I'm a solicitor, I can help you with your problem. But that I didn't do that for 2 reasons. Primarily, one is it sounds a little bit tacky or sleazy, that you think, is this guy just doing videos to sort of sign people up and make money, or is he having a genuine conversation? And the second problem is just, if I said yes to everybody that asked, I wouldn't have any time. I'd basically overload. So what we're trying to do now is set up a department at Virgo where people will be able to get help, and they won't be told we haven't got capacity, and they will receive a quality service, because that's the other side of the coin. You can say, yeah, I'll take your case on, and then you don't have time to actually deal with it. So no, you don't have to ask for me. The question Cheeseface had was, if somebody goes to Virgo, would they need to ask for me specifically? I mean, you can do if you want, but if you say you've got a housing problem, they'll take the details, and somebody will get back to you. We can't always take everything on. We do have to cherry pick a bit, because if it's something that doesn't need a solicitor, we might, or we're just that busy that week, we might have to say so. So Andrew said it was over 55 admittedly, so and I think this is back to the other case. Yeah, that was good news. We've got Mark. Don't think Mark's asked a comment or made a comment or asked a question this week. Hi all from Mark. Hello Mark. After 5 months and 6 days, hopefully tomorrow, I can move into a new place just 15 miles away. Well, congratulations, and I hope you can. And that's good. Well, 15 miles. I mean, anyway, I mean, I don't want to talk about your personal situation, but see, 15 miles, I mean, it sounds like you're being quite stoic about that. A lot of people would say that's too far, especially in London, but that's good news. And so we got a comment here. Robert has been rejected 6 times. Sorry, did I miss an earlier comment about who Robert is? But let's just say Robert is person Y, rather than go for details about Robert. So he's been rejected 6 times. They keep repeating he's not in priority need. Well, my advice is that you should, if they do tell you, I mean, if they reject a homeless, they being the council reject a homeless application and say you're not in priority need, you should presumably get that in writing. I'm sorry if this has been put in writing. You say, okay, fair enough, put it in writing please, and then I can request a review, and then request a review, and then we're back to where we started earlier with the medical. You can get medical evidence or put arguments to show that the council haven't obtained medical evidence, because you may think it's a bad situation if you need to challenge a homeless non-priority need decision vulnerability, but you can't get a GP report. You can say to the council, well, you need to get the report because we can't get one. They won't give one to us, or you've got to come up with some other way of evaluating this. So you can challenge it that way. So I hope Robert's able to do that. And that, I think, is... Yeah, we're getting a few more comments this week. It's...
You guys got time for a quick question that you probably don't know the answer for, but I'm just
Yeah.
interested. So, I'm just interested to see if there's any way a housing officer would have a duty of care to a homeless person. It's on the back of it. I can't remember if I said to you guys, but I did a safeguarding alert to about a hospital worker, basically a discharge worker who refused to do a duty to refer. And the reason I was confident doing that is because they did have a duty of care to the patient and they just flatly refused to actually follow it. But it just made me think in terms of so it seems the case law on housing officers having a duty of care is that there isn't one. But I was just wondering, at what point would a duty of care arise where a council has a duty to a person under the Care Act? So because I'm assuming social workers have a duty of care, and if you're a housing officer and you're aware that someone appears to have care and support needs, and therefore the council's under a duty under the Care Act, would that potentially bring in a kind of a duty of care? Essentially, what I'm thinking of is raising safeguarding alerts against a housing officer for just basic failures. I've just been looking at it up recently and kind of looking at what neglect is and that sort of stuff, what's institutional abuse and so on. And it does appear to be limited to situations and professions that have a duty of care. So I don't know, it's probably not something you know off the top of your head. But I'm just interested to see if you've got any thoughts on that. As I say, if nothing else, at what point during a Care Act assessment does the council have a duty of care to a person? Because I'm just thinking, as I say, that duty might arise during a homeless application without the housing officer actually realising it. So yeah, if you don't know now and you find out later, let me know, basically.
Karis, Shannon, do you want to have a stab at that, or shall I have a go?
I'm not expecting it from you guys. It's very niche question, I guess.
I would say, as far as I know, they don't have a duty under the Care Act specifically. But Will can take over.
Even if it was like a Care Act assessment, it would be the social worker that would have any duties rather than the housing officer, wouldn't it? So you could maybe make a safeguarding alert against a social worker or whoever's carrying out the Care Act assessment if it does constitute a duty of care. But I don't know if that would fall under the remit of a housing officer.
Yeah.
Yeah, I
I
don't
have no
know.
idea.
Yeah. I mean, it comes back to, is it the individual worker who's got the duty of care, or is it the council? So there's a little bit like, kind of where the council's got a duty to take homeless application. It's not actually the officer who's got a duty; it's the council. So it doesn't matter what department does it; it's the council's got a duty to do something. But I just wondered if something similar works for the concept of duty of care.
If that was the case, then would you make a safeguarding alert against the council as an institution, and then would it count as institutional abuse because it's an institution and not an individual?
So it's not exactly clear because the guidance on the Care Act contradicts itself. Because at one point it's saying neglect can be done by anyone, kind of that anyone can kind of carry out neglect. But then it kind of says, no, there needs to be a duty of care. And with institutional abuse, again, it needs to be a care setting, so hospital, care home, that sort of thing. Even though, what we're seeing with gatekeeping or something like that, it's very clearly it's just systemic denial of rights, but it doesn't appear to meet that definition. But it also says elsewhere in the guidance that the councillors, everyone should kind of take a not a narrow approach to the issue. So I'm just, as I say, you can kind of guess where I'm going with this. I'm, looking at, potentially raising safeguarding alerts against housing officers where there is just kind of blatant failures. So I don't know.
Well, I think, just in terms of the duty of care, and this is a really legalistic answer, and it may be unsatisfactory, but the duty of care is a term that's often used in a wider sense, but in a strictly legal sense, it comes from private law, and when you're a law student, it comes under the law of tort, T-O-R-T, which is a non-contractual civil wrong rather than a contractual one. So that if the leading case on it is one that people often study in my day, in your first sort of couple of weeks at university, which is called Donahue and Stevenson, and it involved a lady who bought a bottle of ginger beer and found it had a dead snail in it, And the question is, on what basis did she sue? And now that I raise it, it's funny. It had to go all the way to the House of Lords. And my father told me that he once met the judge who made the judgment in it, and told him what a pleasure, honor it was to meet the man who'd done the decision in Donoghue and Stevenson. But anyway, they said that they owed a duty of care to check that they didn't put snails in the ginger beer bottles. You could say nowadays that with statutory protection for consumers, you'd say, well, surely it's a breach of the Sale of Goods Act or something like that. You don't buy something. But in those days, it wasn't. You buy a bottle of ginger beer, you get a bottle of ginger beer. Oh dear, it's got a snail in it. Nobody saw that one coming. But the duty of care meant you actually had to sort of think about foreseeable harm. And that's evolved as a sort of private law remedy against people. And it would be things like, it's a lot of it's been taken over by statutory things like occupier's liability. If I go into a building and I slip, they had a duty of care to keep the floor dry. But in public law, and this is the problem, the duty of care is likely to give rise to a sort of what the courts and lawyers call a floodgate situation, where they get opened, and every I mean, if you think about if you could sue local authorities for all the cases we deal with where they displayed a lack of duty of care, they'd be out of business, or they'd have to take out such massive insurance that it would probably cripple the service. So what they've said in case law is that there is no private law remedy against people who are discharging a public law duty. And the difference would say, so a housing officer is not entering into an agreement with anybody to sell them the equivalent of ginger beer. There's no money changing hands. It's a public function, and that's all dictated by statute. But although that has meant that things like the leading cases, one which I think we may have talked about before, where some people with special needs got put in a flat where they were they weren't properly supervised, and they were tortured and held hostage by people. A really horrible case, and they were put through all sorts of terrible things, and they sued. And the court at first instance awarded damages against the local authority and said, well, these people suffered and you had a duty of care. But it was overturned on appeal that no, they didn't. It was a public law duty which didn't give rise to civil liability. But then that's just the legalistic side of it. But if you're looking at it from the point of the question you're asking, Mike, I think you could criticise and raise the issue, because the duties that the public sector staff are discharging, whether it's under the Housing Act or Care Act, still give rise to very high standards of assessment and inquiry. And so if somebody did an assessment, say, of somebody's care needs and just said, oh, it doesn't seem to, nothing seems to be wrong with it here, you could challenge that by way of judicial review and get an order requiring them to do the work correctly. What you probably wouldn't get, unless there was a sort of something that amounted to a breach of human rights, would be compensation. Because I think the courts are terrified of coming up with a sort of American-style system where everybody's wanting compensation. Does that answer? Does that?
Yeah, I mean, it's not so much the compensation I'm really asking about. I'm really just talking about kind of how you push up professional standards. And in one sense, if you've got professionals who have had, so with this discharge worker, I don't know what's happened behind the scenes. I'll find out at some point. But I would imagine, to have a safeguarding alert raised against you, and I think, as I say, in that setting, I'm confident that was a correct application of the definition of neglect. You would imagine that they'd be kind of motivated to not let that happen again, and they take it more seriously in future. So it's kind of almost a good way to kind of correct overt, blatant disregard of the law. So I'm not looking at kind of claiming compensation. I wouldn't know how to do that, but no. I'd be looking at how do you give some sort of some currency to following the law, because at the moment professionals don't follow it and there's no repercussions really. But if you start getting someone, if you start getting safeguarding alerts against you, that might make you think twice about following your team leader's orders to break the law.
Have you raised a complaint about them?
Sorry, Karen, go on.
Sorry.
Yeah, so that's it's in the pipeline. So I mean,
Yeah.
I've kind of we've kind of resolved the initial problem of them being without a roof. Raised a safeguarding alert as part of that, but yeah, I think the complaint will be coming to the NHS trust that the hospital is part of, I guess. So yeah, I think there's more to say about it. But when I raised the safeguarding alert, I didn't get a clear answer from the social worker, because what actually happened was the day after after this has all happened, they then did a duty to refer, and the social worker said, well, it's not abuse because they've done the duty to refer, and I was like, that's ridiculous. That's a day late. So there'll be some issues around that as well. But anyway, yeah. So yeah, I think I'll find out more about it. But I'm just, I don't know, just as I say. Sorry, go on. I was just gonna say, well, what options do we have to try and push standards up in the sector and disincentivize breaking the law and leaving vulnerable people at harm's way?
So with housing officers, I'm probably stretching it here. Would it constitute domestic abuse? Because the definition is personally connected. Now, I've sat in that interview room and I felt personally connected to my bloody housing officer. I tell you that for nothing. And it wasn't even a particularly bad interview, but I would have said it felt borderline abusive at times, and full of gaslighting and everything else. So, like, what then is the definition of personally connected? Because I would say, actually, if you're sharing such intimate decisions, and all right, I think you would struggle to not get them, you'd struggle to sort of say coercion and control, because actually they're in a position of power and it is their job to control to a certain extent. Do you know what I mean? But actually that sort of the coercion when someone gets pushed into supported accommodation, for example, because they get sort of like not told all of their full options, or the, like we were talking about, the medical evidence, and actually the sort of, and I know this is not going to be the case for everyone, but the gaslighting that can come with that. Well, actually, you're not that bad because you're sat here now, or you're not that bad because you're not on your meds, or whatever it might be. Like that is. And I know, look, if it feeling abusive is not the same, and I'm playing a bit of devil's advocate or whatever, but I would say that, I don't know, is it
No, I
personally
think
connected?
it's abusive. No, it's definitely abusive, but it's not domestic abuse, because so the definition of personally connected is basically you need to either be kind of related to them by blood or marriage, or have been in a kind of exclusive relationship with them. So that's kind of what it's talking about there. But everything you just said, everything else you just said is completely correct. It is coercive to basically shoehorn people into hostels. It is abusive to to kind of gaslight people and say that there's nothing wrong with them when there clearly is, all that sort of stuff. So it's definitely, as I say, it's kind of that those things are all, I would say, are abuse, but there seems to be, I don't know. I think there's something within the kind of the Care Act's definition of safeguarding and abuse and that sort of stuff, which would allow, where you've got a housing officer who is being just really rude, kind of really verbally abusive, and it does happen. I think there's kind of scope in there to kind of actually make these kind of complaints. I'm not talking about kind of formal complaints, but I'm talking about raising them formally as kind of as an issue of abuse, even if yeah. As I say, I think neglect and institutional abuse are quite specific, and they're quite different from a housing officer just being plain abusive. Kind of, as I say. So I think, yeah, I just think there's something within this which would kind of be another avenue to kind of pursue bad conduct.
So when you see the posters in housing options or GP surgeries, or like wherever, you see the posters saying our receptionists or our customer service people or whoever won't tolerate abuse, it will like pursue legal whatever. What are they pursuing? Because if that can be done from a professional to a member of public, and it's like generic abuse, under what law are they doing that under? Because then that was same would apply, would it not? So it might not be Care Act specific, but it could be.
Yeah, I think this is the kind of thing which I think there's mileage in it, because I think when you think, probably what they're mostly talking about is someone being very intimidating and swearing in their face and throwing stuff at them, which is, we know is just one form of abuse. But yeah, I just think, it is abuse. It's abusive to I don't know. It surely must be abusive to use your position of power to deny someone housing unlawfully. That's got to be abusive in a broader sense of the word. But anyway, yeah, I don't know. I just think there's stuff in there. Sorry, Will.
Another thing I have to pledge to do is watch your video that I haven't watched yet, and it's been a couple of weeks. The one you said that you made a safeguarding complaint against a hospital or about a hospital. And maybe if we all watch that, well, you don't need to watch it. Well, Shannon, maybe you've watched it, but if I watch it, then we can maybe discuss this, because it's a really good point that you're raising, and I think it's one that we all get a bit battle hardened and exhausted. So we're so used to getting the minimum for people that we take it for granted that they're going to get abused by local authority or people that are supposed to be helping them. Just like, you know, if people say to me, I don't want, I say, I think you ought to get help from children's services, and they say, good God, I don't want social workers anywhere near me, and I tend to sort of say, oh, well, fair enough. Whereas I should say, well, hang on, you should, the term social services does mean something in terms of providing support. It's not just about what people have experienced, and they're the same with just the hostility with which people get treated in housing. But then that's in such contrast to the things like, if you read, I mean, the best examples are housing association brochures where they talk about they're passionately committed to helping people overcome disability. And in reality, that was written by a consultant who probably spent a week getting paid a lot of money to write a load of rubbish for them, and nobody's actually done anything about it. But you don't call that out, really. But maybe we mustn't lose sight of that, because I think the other thing is part of you, Mike, is saying safeguarding thing is not meant to safeguard people against the safeguarders. And then people are going to say, don't be stupid, Mike, you're getting, that's ridiculous. But I think the thing is, it's when you do push that. I remember when Jan Luber ran the case, there was a case called Smith and North Avon District Council in 1992, where he got it held that the Children Act applied to housing. And so where people were intentionally homeless and were getting told, sorry, there's nothing we can do for you, they were entitled to go to children's services and say, you owe us a duty. And everyone said in those days, don't be stupid, it's nothing to do with housing, that's to do with, children turning up at school with bruises or something. And the courts held no, that there is a duty there, and the well-being or development of children needs to be protected. And if they haven't got a home, and if that hadn't, when I read that, I thought, wow, you really must never get into that don't be stupid mentality, because it's there. And I think that even if, it's not like it's an abuse of the system, I'm using abuse too widely, but if for you to it's not like you're wasting their time, or people that call 999 because they run out of nappies or something. So yeah, let's talk about that some more, because I think the standards need to be upheld, and if it's only if people hold people to account that they get upheld. So that sounds a bit pompous.
Cool.
No,
I mean, so Luke Clements, in that event we did last year, he basically, I mean, it was in a setting where I'm not sure he was kind of expecting to be taken kind of, at his word sort of thing. It was kind of an off the cuff remark almost, but he kind of said, it's definitely a safeguarding issue, and it'd be a good way of dealing with it. But I guess I'm just prepared for a social worker to knock it back and say, what you're talking about, this isn't abuse. So I just want to say, well, actually it could be, so you need to take it seriously. Yeah.
Because
also, you can talk about the misconduct in the public office.
Yes.
Yeah, MIPO.
Yeah, which again, I think there's mileage in that as well. But I think because there's a couple of related offences which I still haven't had any kind of clarity on. But there's misfeasance in the public office, which I think again I don't understand why it doesn't apply. But you've got housing officers deliberately not housing people. It seems like there should be something else to kind of to motivate them. I know we raised that question as well in that event last year, and Giles Peake was like, no, it doesn't. But I don't know. I want to know why. I guess it just seems like there's something in it which is, there's some useful stuff in it. I've got to go, by the way, guys. I'm really sorry. I've got stuff going on.
No, it's 1:30. So let's carry on talking about that next week.
I've got to go right now, but yeah, just I love you guys. Take care. See you soon.
Yeah.